Welcome everybody. My name is Richard Ascroft. I'm a barrister at Guildhall Chambers. A large part of my practice is company law and shareholder disputes in particular. This webinar, which is part of a series being hosted by Guildhall Chambers, focuses on company deadlock. So if that's not what you are expecting, feel free to log out. I should just say at the outset that I'm not offering any magic solutions to deadlock, but I'm just going to canvass some of the ways in which people seek to anticipate how to deal with deadlock, or what remedies there may be when people haven't really turned their minds to it. What is meant by deadlock in the company law context? I suppose a lawyer's answer might be, well, it depends. What you sometimes have is say, where the affairs of the relevant company are governed by a written shareholders agreement, that agreement might spell out what is to constitute deadlock and include mechanisms for seeking to resolve it. Most cases where courts have considered what is meant by deadlock arise in the context of the presentation of a just and equitable winding up petition. Now, a just and equitable winding up petition is typically presented by a contributory, a member, and so it's quite a different animal from a creditor's winding up petition. The grounds on which a just and equitable winding up petition may be presented are not confined to fixed categories. Generally, however, a just and equitable winding up petition is used as a means of ending a dispute between shareholders, but not always. The recognised grounds for a just and equitable winding up petition are what are referred to as a loss of substratum, which effectively means an inability to pursue the business contemplated. That might be because, for example, of the expiry of a patent or other right. Another ground is deadlock. Another is justifiable loss of confidence in management, the expulsion of a shareholder, breakdown of a relationship of trust and confidence. That will be where the relevant company has been operating as what is referred to as a quasi-partnership. Now, deadlock, or functional deadlock as it's sometimes called, as a basis for presentation of a just and equitable winding up petition, was described by Lord Briggs in a Privy Council case, Lau and Chu, as existing where an inability of the company's members to cooperate in the management of the company's affairs leads to an inability of the company to function at board level or shareholder level. He went on to refer to functional deadlock of a paralysing kind, which is an indication of the state of affairs that must exist before one can say there really is deadlock. And in that Privy Council case, Lord Briggs described the existence of functional deadlock. He described that as one of two related but distinct, but potentially overlapping situations where a just and equitable winding up petition or winding up order may be made in response to a falling out between members. One is where there's been a breakdown. Well, that, apart from the functional deadlock, the other way in which one would get an order for just and equitable winding up is where the company in question has been operated as a quasi-partnership, in the sense familiar from cases like Westbourne Galleries. But in such a case where there is a quasi-partnership, then an irretrievable breakdown in trust and confidence may also justify a just and equitable winding up. That doesn't have to be confined to situations of deadlock. So essentially, in the first case, deadlock, the winding up as a remedy for paralysis. In the second case, a winding up order is a response of equity to a state of affairs between individuals who agreed to work together on the basis of mutual trust and confidence, but where that trust and confidence has evaporated. The classic case where there will be complete functional deadlock is where the relevant company has only two shareholders, each holding the same number of shares, and each of them is a director. Now, in the same case, Lau and Chu, Lady Arden considered different meanings attributed to the word deadlock in other cases, but she was careful to say that the judgment of the Privy Council in that case did not seek to provide a particular definition of deadlock. What she did say was that, in the interests of clarity, the use of the term deadlock to describe a category of case where the court is considering a just and equitable winding up petition should be reserved for cases in which there is complete deadlock at the level of management, and that is the only matter on which the party is seeking a just and equitable order. Now, the phrase complete deadlock at the level of management is important because that would suggest that deadlock at shareholder level would not be enough, at least if the board is not deadlocked. So, for example, you may have two equal shareholders but only one director. That would not be complete deadlock at the level of management. In this talk, unless otherwise stated, where I use deadlock, where I refer to deadlock, it's simply shorthand for the inability to conduct or manage a company's affairs because of conflict between those in control. So, deadlock may occur at shareholder level, board level, or both. It's often, but not always, the result of an equality of voting power. Now, in a case decided in September last year, a case called Recosa Limited, there was no deadlock at shareholder level or board level, but the court took the view that in the unusual circumstances which prevailed there was still deadlock, or at least something very akin to it. Now, as I say, the case is called Recosa Limited. I think it's probably more accurately called Recosa Limited number 25 or 38 or something, because the protagonists had been in dispute since 2016 over where the control of the company should lie. And by the time it came before the judge in September, there'd already been 25 applications to court, 17 hearings in the High Court, 4 in the Court of Appeal, and 1 in the Supreme Court. Now, that was a just and equitable winding up case. What was unusual about it was the petitioner owned 100% of the ordinary shares in the company, and those were the only shares that had that enabled the enjoyment of economic rights, so the rights to dividends and things of that nature. The difficulty arose because the company's sole director, Mr. Ippick, held one ordinary share. So although an ordinary share, it didn't confer on that director any material economic rights. But what it did confer on him was a power of veto in respect of various matters, and it was that which had given rise to the claimed state of deadlock. So, as I say, although on the facts there was no deadlock at shareholder level, the applicant having all of the voting rights, at a board level, it meant, because of the right of veto, that there was a form of deadlock. And that was, said the judge, a classic example or akin to a state of deadlock. Now, there's a fairly recent case again last year, a case called Khan and Mir. This involved the presentation of by one of two equal shareholders of a just and equitable winding up petition in respect of a company called Nima Tandoori Limited. No prizes for guessing the nature of the company's business. It was the operation of a restaurant. The trigger for the alleged breakdown of the relationship between the shareholders was some form of physical alteration, the particulars of which the judge was unable to make any particular findings of fact about. But that altercation took place in July 2022. No petition was presented until some 2 years later. Now, His Honour Judge Keyser, King's Counsel, was the judge, and he expressed the view that the fact that the company had been able to continue in business since that altercation was not conclusive of the absence of functional deadlock, but nevertheless, in what was a two-person restaurant business, the continued ability to trade in those intervening 2 years was some indication that there was no relevant deadlock. And he presumably reached that conclusion because in those circumstances you would expect there to be a requirement of close day-to-day cooperation. And if it managed to continue functioning 2 years after the alleged trigger for the claimed deadlock, then it probably wasn't properly in a state of deadlock. Now, as I said a little earlier, voting equality is not always the cause of relevant deadlock. Sometimes deadlock is caused by an inability to satisfy quorum requirements, which might be specified in the company's Articles of Association or in a written shareholders agreement. Now, at its worst, deadlock can, unless remedied in some way, lead to a near total paralysis of the company's affairs, with significant implications for its continued trading. Sometimes, of course, it might be said that the risk of deadlock is expressly contemplated when the relevant company is incorporated. A structure of equality, so equality of shareholding and rights of appointment to the board and so forth, may be deliberately adopted by the parties as a means of ensuring close cooperation between them. In such circumstances, deadlock is not necessarily a bad thing. It's simply regarded as a protection for each of the shareholders. Now, how can one go about addressing deadlock? One can try and anticipate that by making provisions at the time the company is set up. If the model articles are adopted, for example, Article 13 for private companies, Article 14 for public companies, provides that where there is an equality of votes for or against a particular proposal at board level, the chairman, if there is one appointed in accordance with Article 12, or other director chairing the meeting, shall have a casting vote, unless the chairman or other director is specifically not to be counted as participating in the decision-making for quorum or voting purposes. Older companies which have adopted Table A, 1985, they may be able to rely on the similar provision in Table A, which is Regulation 88. Now, it's not necessarily a great way of addressing deadlock because although the identity of the chairman or chairwoman may change over time, many shareholders will consider the risk of determination of major decisions by another shareholder's nominated director to be unacceptable because it's effectively carrying a risk of total control in favour of one shareholder. Now, Regulation 50 of Table A did provide for the chairman of any meeting of members to have a casting vote in the event of an equality of votes, but for some reason that hasn't been carried over into the model articles. There's simply no equivalent of that provision. As I say, sometimes the bespoke versions of companies' articles will seek to address deadlock. In Renegade Tobacco Company Limited in 1916, that was a company where there was a quasi-partnership with two shareholders. The articles made provision for what was to happen if there was deadlock at shareholder or board level, and for direct of deadlock, it provided for the referral to arbitration of any matter giving rise to deadlock. Two arbitrators, one appointed by each director, with the arbitrator's decision to stand as a decision of the directors and to be recorded in the minute book as such. Now, one of the matters that was referred to arbitration in that case was whether the factory manager should be dismissed. Now, that gave rise to a hearing that lasted 18 days just on that one issue. So as a mechanism for resolving deadlock, it's obvious that was cumbersome and expensive. Where shareholders try and address deadlock, more often than not, they'll try and do so through provisions in a written shareholders agreement, perhaps rather than the articles. Now, the scope for deadlock can be increased where one resorts to fairly elaborate shareholders agreements, particularly where you've got provisions requiring certain voting thresholds and particularly where they require unanimity. Obviously, the scope for deadlock is much greater. Now, in one case decided a couple of years ago, Garofalo and Crisp, there was what was called a relationship agreement to which some only of the shareholders were parties. That did make provision for dispute resolution and deadlock, but one element of that required the parties to communicate for at least 6 hours over the course of 12 days. I have to say, I've got serious doubts about the utility of that provision, because if it wasn't capable of being sorted out beforehand, I'm not sure that extra time would really work. A shareholders agreement may provide for different responses to deadlock on different issues depending on their perceived importance. One option is to provide for the determination of deadlock commercial issues by third parties. If that's going to be the case, obviously that third party should be impartial, mutually acceptable, and ideally someone with experience and knowledge of the company's field of business. And that's easier to say than it is to achieve. An example of that is a shareholders agreement that was in a case, again, decided last year, Municipio de Mariana against BHP Group. And that made express provision for certain cases of deadlock in relation to specified technical matters to be settled by an independent expert appointed by the shareholders under an arbitration process. Ultimately, however, if the members are unable to resolve the deadlock by negotiation, the agreement, any shareholders agreement, should probably provide for the departure of one or other of them on terms enabling him or her to exit with a fair value for their shares. Now, various mechanisms are put forward and adopted in an effort to achieve that. What constitutes fair value is a question that vexes many experts and courts alike, and is likely to depend on the nature of the company. Where the company is in the nature of a small, closely held company, which has been effectively run as a quasi-partnership, it will usually be sensible for the exit mechanism, at least where there's a compulsory buyout procedure, it should usually provide for the valuation of the departing shareholders' shares on a pro rata, undiscounted basis. For those of you who have any exposure to unfair prejudice petitions and the like, the valuation of a departing shareholder's shares gives rise to all sorts of valuation issues, including the date of valuation, but also the basis upon which the valuation is to be done. It used to be understood that if it was a quasi-partnership, there would be no discount from the pro rata value to reflect the lack of influence. But the case law is now in something of a state of flux, and it's difficult to identify particular presumptions because the court now operates on a slightly wider basis and looking at the overall fairness. Another option to enable a party to leave is what's called a Russian roulette clause. It's probably only of use where there is a two-member company, but that involves a provision which permits one shareholder to buy the other out at a price nominated by the offeror. Typically, such an offer is time limited. It will usually provide for the offeree to accept the offer or to offer to buy the offeror's shares for the same price. And if there's no acceptance within the stated period, then usually there's a default deemed acceptance of the offer to sell or the offer to buy at the election of the offeror. An example of such a clause was contained in a case called Nova Trust Limited back in 2014. Now the danger, there is a danger with such an approach, because if the original offeror is aware that the other member lacks financial resources, he may be willing to offer a depressed price for the offeree's shares, safe in the knowledge that the offeree will be unable to offer to buy him out at the same reduced price. And there's a variation of a Russian roulette clause called a Mexican or Texas shootout, which involves sealed bids by each member to acquire the other's shares. The highest bidder is obliged to buy the other member out. Another response is, at least where the deadlock is at board level, the shareholders might want to think about appointing a third party, an additional director who's mutually acceptable to both parties or all the shareholders. Alternatively, they may want perhaps not to appoint an additional director, but to consider the appointment of a manager who could be delegated with day-to-day management of the company's affairs. Such a process has its limitations. Any delegation is still likely to require a close degree of cooperation between the directors for the giving of instructions to any delegated manager. And of course, some matters, including the approval of accounts, are matters exclusively for the directors, not a delegated manager. And there's also, of course, a cost associated with appointing a manager or even perhaps an additional director in terms of consultancy fees or the like. Now, last November there was a case, Webster against ESMS, where minority shareholders, there are effectively two camps of shareholders, each of whom held 46.7% of the issued share capital. There was a third shareholder, which was an employment benefit trust, with the remaining 6% odd. And in that case, the minority shareholders applied to the court for a mandatory injunction requiring the relevant company to circulate a written resolution for the appointment of a third director to the board. Deadlock at board level having meant that no requisition was acted upon. And ultimately that was successful on the facts. It's quite an unusual situation, but the court held that it could grant an injunction to make sure that requisition was put before the members, including, in that case, the 6% member. Now, it might be a case, or it might be an answer to a case based on purely functional deadlock, that a member could extract him or herself by a sale of his or her shares, at least if he or she could be expected to do so upon fair terms. And what has been suggested in some of the case law, including the Privy Council case I mentioned at the beginning, was that that's probably only going to work where there are no restrictions in the articles on dealing with shares. In reality, as many of us know, the sale of shares in a private company is something of a theoretical possibility, simply because of the absence of any ready market for such shares, and particularly a minority interest. And the market sentiment for that means that any incoming purchaser is going to expect a significant discount over the pro rata value, any third-party purchaser, simply because of the inability to influence the company's affairs. Once you've got a shareholding that's below 25%, because at least with a below 26%, with a 26% shareholding, one can of course block even special resolutions and thereby exercise what lawyers call negative control, once you're down to a shareholding that's less than 26%, you really have very limited ability to influence the affairs of the company. And as I say, a hypothetical third-party purchaser is not going to purchase such shares without a significant discount over the pro rata value. And the reality is the obvious purchaser of shares for an outgoing member of a private company is going to be the other shareholders, or perhaps the company itself if it has sufficient distributable profits. Ultimately, though, and this emerges from one of the only cases to go to the House of Lords on unfair prejudice, O'Neill and Phillips, there is no unilateral right of withdrawal. A shareholder has no right to be bought out, and similarly those shareholders left behind are under no obligation to purchase a member's shares, whether at a fair price or any price, unless the articles provide, which is quite unusual for them expressly to provide for that, or the court makes an order to that effect in response to proven unfair prejudice. Another way of resolving deadlock might be recourse to the provisions in the Companies Act, Section 306 of the Companies Act in particular. Now, this section applies if, for any reason, it is impracticable to call a meeting of the company in any manner in which meetings of that company may be called, or to conduct the meeting in the manner prescribed by the Articles or the Act. And the court has powers under Section 306, either of its own motion or on the application of a member or a director, to order a meeting to be held and conducted in any manner the court thinks fit. And particularly, it can give directions about the way in which that meeting should be conducted. And importantly, one of the directions it may give is that one member of the company may constitute a quorum for the purposes of that meeting. Now, in certain circumstances, recourse to that section can lead to the breaking of deadlock, at least at shareholder level, but there are limits on the exercise of the court's discretion, as we'll see. In a case called Opera Photographic in 1989, the relevant company had two shareholders, one holding 51 of the 100 issued shares, the other holding the remaining 49. The two shareholders were the only directors of the company. Under the company's articles, the quorum for a meeting of members was 2, and for directors also 2. The majority shareholder had requisitioned the company to convene a meeting with a view for the consideration of a resolution for the removal of the minority shareholder as a director. But that meeting was thwarted because the minority shareholder simply declined to attend any board meeting to enable the relevant meeting to be called for consideration of his removal. And the effect of that staying away or refusing to cooperate meant that any meeting was going to be inquorate. The judge, Mr. Justice Morritt, as he then was, held that the minority shareholder did not have what he called a power of veto by virtue of the quorum requirements in the articles. And he directed a meeting of the members to be held at which one member would constitute a quorum for the purposes of the proposed resolution. And he did so even though on the facts in that case, the removal of the minority shareholder, because of that member's contention that the company had been operated as a quasi-partnership, might give rise to an entitlement. The minority shareholder said, "Look, this has been operated as a quasi-partnership. I've got a right to participate in the management of the company." That was his case. The court was still prepared to direct a meeting, even though the removal of the minority shareholder in such circumstances might lead to an unfair prejudice petition. The same principles apply where the deadlock results from quorum provisions in a shareholders' agreement rather than the Articles of Association. As I indicated a little time ago, though, it's not all quorum requirements may be overridden by recourse to the machinery in Section 306. And there are two instances in particular where that's the case. One is where the relevant requirement is for the benefit of a particular class of shareholders. In such a case, the court will not intervene to direct a meeting which does not respect the quorum requirement, even if the holders of the shares constitute a minority. And the other example arises where the deadlock exists between two equal shareholders. And often that's the case where, for example, a divorcing couple who carry on business together through a limited company, each of them holding 50% of the shares. Section 306 of the Companies Act is not an appropriate vehicle for breaking the deadlock at shareholder level. And the reason for that is because Section 306 is a procedural section. It's not designed to affect substantive voting rights or to shift the balance of power. And at least in a case where they have agreed that power should be shared equally. And the court takes the view that the potential deadlock in such a case is something which they must have agreed upon and adopted for the protection of each of them. And so even if you've got two shareholders and one refuses to stay away from any meeting, rendering it inquorate, if they're equal shareholders, the court is not going to enable someone to rely on Section 306 to convene a meeting and have a quorum of one, because that would be to alter the balance of power. There's a convenient summary of the principles relating to this in a case called Vectone Entertainment Holdings in 2004. Another response to deadlock, as I indicated, is a just and equitable winding up petition. Now, a winding up petition is often referred to as a shareholder's remedy of last resort. It really is the nuclear option. Although Lord Briggs in the Privy Council case of Lau and Chu said it was a remedy of last resort, it doesn't mean that winding up is unavailable if the members have another remedy. He said the member still retains what Lord Briggs described as a significant element of choice, even though ultimately the court has the last word. The remedy of last resort point is reflected in the wording of Section 125(2) of the 1986 Act, which provides that if the petition is presented on the ground that it is just and equitable that the company should be wound up, and the court is of the opinion that the petitioners are entitled to relief, either by a winding up of the company or some other means, and that in the absence of some other remedy, it would be just and equitable that the company should be wound up, it shall make a winding up order. But this does not apply if the court is also of the opinion that both some other remedy is available to the petitioners and they are acting unreasonably and seeking to have the company wound up rather than pursuing that other remedy. Now, well, we'll look potentially at what other remedies may exist in a moment. When addressing the question of deadlock as a basis for just and equitable winding up, it's the management of the company sought to be wound up that is the focus of the court's inquiry. Deadlock about other matters outside of day-to-day management are neither here nor there, at least if the company is still capable of being managed effectively. But as the courts have recognised, the breadth of the parties falling out over other business matters may be very relevant to the court's assessment of whether an apparent deadlock has become irremediable. Now, as far as alternative remedies to a winding up order are concerned, a sale of one shareholder's shares, whether to the others or to some third party, is one, but for the reasons I sought to outline earlier, that may not be hugely attractive. And if it's not hugely attractive, the court is unlikely to conclude that a petitioner is acting unreasonably in pursuing a winding up rather than a share sale. What is frequently said in response to an unfair prejudice petition is, oh, hang on a minute, the petitioner has an alternative remedy, and that is to pursue a petition for unfair prejudice under section 994 and 996 of the 2006 Act. The trouble with that is that unfair prejudice petitions, the courts don't particularly like them. They are, in the words of one judge, notoriously burdensome and uncertain in outcome. They are extremely expensive and in many cases have become akin to an old-style divorce petition, because the whole history of the interactions between the shareholders, often going back through multiple generations, has to be canvassed. And further, and in any event, what the courts have said about that is that unfair prejudice in the conduct of a company's affairs is a different allegation from deadlock or breakdown of trust and confidence. And the fact that one can prove one of them may not mean that one can be satisfied about entitlement to the remedy of the other. Now, that's all I wanted to say about, with that quick canter through. I just have a word of warning for those acting where the company appears to be deadlocked or maybe, and that's this. And I'm sure most of the people tuning in will know this, but subject to any particular provision to the contrary, the power to instruct solicitors on behalf of a company is vested in the directors under their general management authority, and that's conferred usually through the Articles of Association. Any decision to instruct solicitors should be taken at a properly convened meeting of the board, or it should be the subject of a resolution of the board in writing. Where the company has more than one director, then absent specific delegation to a single director, any decision to appoint solicitors must be made by at least a majority of the directors. Now, a failure by solicitors to satisfy themselves of their authority to act on behalf of a company can lead to a wasted costs order against those solicitors in respect of any litigation conducted without authority, or an order under the court's inherent jurisdiction requiring the solicitors to compensate a person who suffers loss by reason of any breach of warranty of authority to act. So there are a number of cases that address that. So it is just simply a warning. If someone comes to solicitors saying there's a dispute between the board, I want you to act on behalf of the company doing X, Y, and Z, you must take steps to satisfy yourselves that you have been properly authorised by the board and not just a single director. There has been a very quick canter through aspects of deadlock. As I think I said at the beginning, I'm not offering any magic solutions. Obviously, anyone who has any questions, please feel free to email me at Guildhall Chambers. My email address is a real mouthful, but it's richard.ascroft without an H at guildhallchambers.co.uk. I'm sure you can find the details on the Chambers website. Thank you all for listening.